All right, good morning, folks. Today we're going to talk about the judicial branch, the first couple slides of this presentation here, and it was about the first 10 pages of Chapter 10. The judicial branch is addressed in Article 3 of the Constitution, where it says, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time establish. There are no constitutional requirements to serve as a federal judge. Age doesn't matter. Citizenship doesn't matter. Residency doesn't matter. The only requirement is that you are appointed by the president and confirmed by the Senate. Once appointed, you can serve for life. Ruth Bader Ginsburg is currently 87 years old. As you will see, the federal courts have the power to resolve disputes, interpret the law, and set precedent. The court's power of judicial review to interpret the law to determine the constitutionality of legislative and executive actions is not mentioned in Article 3. However, it is clear from Federalist 78 that the founders clearly understood a court to have the ultimate power to say what the law means. This power was exercised for the first time in the court case Marbury v. Madison. Our legal system has three characteristics. First, it emerged from a tradition of common law. This is a tradition where law is made by judges. The role of a judge in a common law tradition is to determine what the law is and then apply past decisions to new situations. A past decision is called precedent. Relying on precedent to determine the correct application of the law is called stare decisis, Latin for let the decision stand. Our legal system is not a true common law system. We are at the same time a civil law system because we have legislative institutions that make law. A second characteristic of our legal system is its adversarial nature. In an adversarial system, the truth or the best version of the facts is revealed through the clash of competing professionals, in this case, lawyers. An adversarial system is designed to determine whether a particular person is guilty. In this system, it is easier to maintain the ideal innocent until proven guilty. Systems that have a pure civil law tradition are said to be inquisitorial in nature. In an inquisitorial system, judges have a different role. They are not impartial referees. They take a more active role in trying to get at the truth. They conduct investigations, question witnesses, and gather evidence. An inquisitorial system is designed to discover who did it. In these systems, the ideal of innocent until proven guilty isn't held as high. In fact, in an inquisitorial system, once a judge has gathered enough evidence to move forward with the trial, the presumption of innocence is dead. The judge essentially assumes the defendant is guilty at this point. A final characteristic of our legal system is that it is litigious, which means we sue each other a lot. To put the litigious nature of America in a positive light, it means that if another citizen were to harm me, both physically and or financially, we resort to the law and a system of courts to be made whole. I no longer have to go gather up my three cousins that weigh 300 pounds each and go beat the tar out of someone to get justice. I can use the courts and the system of law to seek justice. To put the litigious nature of America in a negative light, we are also prone to frivolous lawsuits. So true story here. Here's an example. My mother was once sued by her own stepdaughter over the ownership of a baptismal dress. In the study of law, you're going to run into all different kinds of law. So on this page, we have two kinds here, substantive and procedural. Substantive laws are those whose actual content or substance defines what we can and cannot do. Think behavioral codes or criminal codes. I know substantively that I cannot buy, sell, or distribute recreational marijuana in Minnesota. Procedural laws, on the other hand, establish the procedures used to conduct the law. That is how the law is used or applied and enforced. If I'm arrested for buying, selling, or distributing recreational marijuana, procedural law requires the police read me my Miranda rights. Failure to do so would be a procedural due process violation. This is where we can see a conflict between these two kinds of law. When a person gets off on, quote, a technicality, what we are actually saying is that there was a procedural law violation. All right, still more kinds of law. Okay, so statutory law are those laws that legislative institutions make at either the state or national level. So statutory laws sometimes might be substantive, sometimes they might be procedural. Administrative law is the law established by bureaucracies, in our case, on the behalf of Congress. Administrative law includes the thousands of regulations made by agencies when exercising their rulemaking authority. Executive orders fall into their own category. Technically, they are clarifications of congressional policy issued by the president that have the force of law. Finally, a category of law not present on the slide is constitutional law. The laws that establish the institutions of government, their powers, their limitations, and of course, all the amendments, so guarantees of basic rights as well. We will be studying guarantees of basic rights next unit. As stated earlier, there are three roles the courts play: resolving disputes, interpreting the law, and setting precedent. We will talk about the difference between resolving disputes and civil and criminal disputes in the near future. Okay. So there are two approaches or ideologies to interpreting the law: strict constructionism and loose constructionism, or sometimes it's referred to as judicial interpretivism. A strict constructionist believes that if the meaning of the Constitution is to be changed, it must be done by amendment. Strict constructivist judges take the view that the Constitution means exactly what it says it means, and that all interpretations are informed solely by the framers' intentions. A loose constructivist or judicial interpretivist holds that the Constitution is a living document and that justices should interpret the Constitution in the light of social changes. There is a similar divide in a justice's attitude towards their third role, setting precedent: judicial restraint versus judicial activism. Justices with an attitude of judicial restraint believe strongly in the principle of stare decisis. They are less likely to overturn established precedent, more likely to actively reject the notion that judges can, quote, legislate from the bench. Those justices with an attitude of judicial activism are more likely to overturn precedent. They don't adhere as strongly to the principle of stare decisis. They are more likely to issue decisions that shape policy, essentially dipping their toes into the realm of lawmaking. So, on to resolving disputes. There are two areas of law when we talk about this function of the court. If the dispute is between government and an individual, we are in the realm of criminal law. Criminal law is that portion of the law that defines public wrongs. In that regard, it overlaps with substantive law. There is language that is particular to criminal law. The person bringing the case is referred to as the prosecution. The prosecution will always be government. Remember, the dispute is between the government and you, not the reverse. The prosecution can be a state, such as Minnesota, or in the case of federal law, the United States. If a jury rules against the defendant in a criminal case, the defendant has been found guilty. A guilty verdict can lead to a fine, imprisonment, or even death. Because the penalties can be severe, and because we are always concerned about governmental power, we require government to achieve the highest standard of proof before it can take our property, our liberty, our life. Standard of proof is the amount of evidence necessary to gain a conviction. In criminal cases, the standard is beyond a reasonable doubt, which doesn't mean zero doubt. It means that a reasonable person of average disposition and intelligence would believe that there is no credible doubt to the accusation. You will also note that the burden of proof is on the prosecution. This preserves the presumption of innocence. The defendant has no burden whatsoever to prove his or her innocence. If the dispute is between two private individuals or between a private individual and government, we are in the realm of civil law. This is the portion of law that allows me to recover damages or make myself whole if an action taken by another person were to harm me physically and or financially. The two often go together. For example, and by two going together, I mean civil and criminal law often go together, they overlap. Okay. For example, if I walked down the hall, went to Mr. Anderson's classroom, and sucker punched him, the police would arrest me for the criminal act of assault. However, Mr. Anderson could sue me under civil law, hoping to recoup the cost of having to replace all his teeth. There is also language particular to civil law. The person bringing the case is referred to as the plaintiff. If a jury rules against the defendant in a civil suit, he or she has been found liable for the damage to the plaintiff. The defendant is then charged with making the plaintiff whole. This will often mean an award of money or other property. The standard of proof, the amount of evidence needed to find the defendant liable, is not as high in a civil case. The standard of proof in many civil cases is by a preponderance of the evidence. This means that it is more likely than not that the contention is true. You can think of it as a majority of the evidence says you did the deed. And that's it. The next topic is the structure of the courts and jurisdiction, which you should already have a pretty good handle on. So, we'll talk to you again and see you all later. Bye.